Okay, why don't we start? Again, like I just mentioned, my name is Jessica Keegan. I use she, her pronouns. I'm coming from the Office of Economic Empowerment. And today we are super lucky to be partnering with South Coastal County's Legal Services on understanding credit card debt. So I'll go ahead and start us off. So we'll just briefly do an introduction here, tell you a little bit about the Office of Economic Empowerment, some standard disclosures, housekeeping, and then, of course, the presentation. We'll have time for questions at the end, of course, and you can use the Q&A function to ask questions as we go through. So a little bit about the Office of Economic Empowerment. We are a department with the Massachusetts Treasury. We are aiming to deliver programs to all residents of Massachusetts at every stage of their lives, regardless of their economic backgrounds. So we offer initiatives tailored to meet the unique financial experience of veterans, women, high school students, and older adults. But in general, we are aiming to promote economic empowerment and equality all across the state. So we'll pause here for a little splainer and let me know if you can hear this with a thumbs up, Erica or Lauren.
Your financial well-being is our priority. The State Treasurer's Office of Economic Empowerment is here with free financial education to make your tomorrow even brighter. If you live in Massachusetts, you can access no-cost resources and online training, all designed with you in mind. Take it at your own pace or build community and learn with others. We offer help with budgeting, building credit, education and vocational training savings, financial wellness for families and communities, maximizing your money, planning for retirement, and more. Whoever you are, wherever you are in your financial journey, and whatever your money goals may be, we have the tools you need to succeed. Get started on your path toward a healthier financial future. Visit mass.gov/treasury/empowerment to learn more.
Great, that was our OE explainer video, so to speak. It was just a 1-minute view, a little bit more about the Office of Economic Empowerment and what we do, which includes workshops like these. So just as a reminder, this is a Zoom webinar. It will be recorded. This recording will be uploaded onto a public website for future use. So I'll make sure to send in a follow-up email, the link to the recording on our YouTube channel. Since we are a state organization, the chat record is subject to public record law, as such is not anonymous. However, just know that when you're using the Q&A functions, you can ask questions with your name or through an anonymous question, so you'll still be able to ask questions that way. You may have noticed that this is a Zoom webinar and not a meeting. As such, you'll not be able to turn on your camera or your microphone. However, if you have any questions or you need anything, you can definitely use the chat or the Q&A throughout the whole webinar. And once this webinar ends, a little post survey will pop up and just let us know what you thought about how this went so we can better serve you in the future as well. So I will turn it back over in a moment. If you want to learn more about our upcoming events or more about the Office of Economic Empowerment, definitely check us out through these links. And I will hand this over to Erica and Lauren. Thank you so much to our partners at the South Coastal County's Legal Services.
Hey, how's it going, guys? My name is Erica Lascano. I'm the supervising attorney of the consumer unit at South Coastal County's Legal Services. We're a fairly new unit opening last June, and we're here to talk to you about understanding credit card debt.
And I'm Lauren. I'm also an attorney in the consumer unit with Erica at South Coastal. Nice to see everyone.
All right. And before we dive in, I just want to say that in my previous life, I worked for creditors collecting debt. Some of the clients were large national banks. So I do have some insight that's valuable to this specific topic. And that will come in handy once we start talking about the litigation process. So I'm going to take a second here and share my screen. And we will start. All right, Lauren, can you give me a thumbs up that you can see the full screen? All right, so we've got 3 sections. I'm going to start with the first section. This is meant to be a really broad overview of how credit cards work. We're not going to get too in depth because we want to focus on managing credit card debt, and then the third section, which is debt collection and responding to a lawsuit. So revolving credit, the ABCs, understanding how credit cards work. All right, so credit cards provide a revolving line of credit, meaning you can borrow repeatedly up to the amount of your available credit, and you can keep borrowing month after month as long as you repay enough that you never owe more than your credit limit. So, for example, if you have a $10,000 credit limit, you open up an account, and in the first month you spend $5,000. The next month or continuing forward, you would have an additional $5,000 of open credit. As long as you pay back the amount on a monthly basis, the bank will continue to lend you money, and you'll use it as you go. If you pay back the money you borrow within the grace period of, it varies by card, 17 to 30 days, you don't have to pay more than you borrowed. If you don't pay it back in full within that grace period, you'll have to pay the money on the interest. You have to pay interest on the money that you borrowed. The grace period is the period between the end of the billing cycle and the date that your payment is due. So that's a little hard to conceptualize as I'm saying it. But let's say, for example, that your billing statement ends on the 2nd of the month. Your credit card statement comes. It's going to tell you spent $1,000. The statement closed on the 2nd. And your $1,000 payment is due by the 22nd of that same month. If you pay that full $1,000 by the 22nd, you're not going to have to pay interest on that $1,000. If you only pay a portion of the $1,000, then interest will accrue, and you'll have to pay interest on top of the money that you borrowed. Interest is the price that you pay to borrow money. So people charge interest as a business aspect. So banks make money by lending you $1,000 and then collecting $1,010. It's kind of the concept of how financial institutions make money, is charging credit. Typically, credit cards are unsecured lines of credit, meaning that the debt isn't secured by collateral. And the lender can't seize your property that you purchased if you fail to make or fail to pay your balance. The unfortunate thing is that your credit can be damaged. So in terms of collateral and what that means, credit cards are unsecured. So collateral is an item of value that you pledge to secure a loan. An example of a secured loan would be the two most common are buying a car or buying a house. So if you buy a car, you take out a loan, let's say you buy a $10,000 car, you're taking out a loan for $10,000. And in the event that you are unable to repay the loan, you're also promising, or the institution that lends you the $10,000 is allowed to repossess the car from you in order to sell it to regain some of the money that it lent you. In this instance, credit cards are unsecured. You're not putting up collateral. And if you buy something with a credit card and then you don't pay, let's say you buy a car on a credit card, you buy a $10,000 car on a credit card, you don't pay the credit card back. The credit card has maybe legal recourse down the road, but they can't come and take your car from you. And that's why credit cards and getting a credit card is based on one of the factors is credit worthiness and your ability to repay the loan. And getting a better interest is determined by your credit worthiness, is at least one of the factors. The contractual relationship between a credit card issuer and a credit card holder is governed by the terms and conditions of the account. So those are just kind of the basics that we'll go over. And I just want to highlight the difference between an installment loan and a revolving credit card loan, which we went through. So an installment loan, like I said, this is typically the biggest examples are buying a house, buying a car. You're borrowing for a single lump sum. It's typically got a specific payback period, and it's a fixed payment amount. Revolving credit is you can borrow up to a predetermined limit. It offers flexible borrowing as needed, and payments are based on what you spend. Interest rates can be pretty difficult to figure out. I know that if you have a credit card and you're looking at the interest rates, there's a lot to swallow for sure in a statement. So a credit card's interest rate is the price you pay for borrowing money. For credit cards, the interest rates are typically stated as a yearly rate, and this is called the annual percentage rate. We're going to abbreviate that to APR. And that's what you're going to see all over your credit card statement or your terms and conditions is you're going to see APR. Federal consumer law requires that lenders disclose APR. Depending on the lender, APRs vary based on the type of charges you make, and we're going to go over what that means. There are various factors that influence the APR that you personally get on a product, a credit card product. So credit history, income, and the market prime rate are a few examples of items that influence the APR that you get. Some of those items are in your control, others are not. And again, you can avoid paying APR by paying off your monthly statement balances in full within the grace period allotted. So some common kinds of credit card APRs. There's introductory APR, promotional rates. So again, remember that credit cards are financial products, and like any financial product, they try to advertise something that's lucrative to you, that means something. So a common thing that you'll see for introductory APRs is they will say, we will give you a 0% interest for X amount of months. There's balance transfer APRs. There's purchase APRs. Purchase APRs, it's just the APR on what you would spend to go get a cup of coffee or an ice cream. Cash advance APR. So if you take money out of an ATM using your credit card, you're going to have a different APR than perhaps what the purchase APR is. It might be the same, it might be different, but you have to check your terms and conditions to determine what the APR rate is. And then there's penalty APRs. Typically penalty APRs naturally kick in if you're over 60 days late on your payment. And just to kind of backtrack and highlight some things with these is the next slide, we're going to talk about introductory APR versus deferred interest, which I think is really important. And it's a financial trap at times. For cash advance, the one thing I want you to be wary of is something that you may not consider a cash advance may be. So for example, the credit card company may treat you using your credit card on Venmo to send somebody a payment, a cash advance. And the reason that's pertinent is because if you just think, if you have a 10% APR, purchase APR, and you think you're only going to be charged 10% in the event that you don't pay it back in the grace period, and you send somebody a Venmo for $10,000, but your cash advance APR is like 30%, you want to be aware of the differences in APR. So read your terms and conditions, and you can determine things that you would not consider cash advances and would trigger that kind of APR. You can figure that out. So the really important one that I want to talk about is zero interest versus deferred interest. And I saw this a lot in my previous position. People taking out loans. Specifically, there is a home improvement store that will say 0% interest is kind of what it's advertised, but it's really deferred interest. And somebody would buy $15,000 worth of flooring, have 36 months to pay it off. It would not be paid off in full in those 36 months. And then all of a sudden they're left with paying interest on the accrued 36 months. And I'm not going to go too into detail into this, but here's just a basic example. So in this example, you've purchased a $400 TV. And this is the difference between 0% interest and deferred interest. So in this scenario, you are paying it off in 12 months. So a 0% interest promotion will not add interest based on the balance of your promotional purchase during the promotional period. Even if you have an unpaid balance after the promotional period ends, you're only going to pay interest. You're only going to pay interest on the remaining balance. So in this scenario, you've purchased a $400 TV. For 12 months, you've made payments totaling $300. So that means that there's $100 left after a year of paying on it. The promotional interest rate was 0%. So you've accrued 0% during those 12 months in interest, which means you don't have to pay any interest. And when that promotional rate's over, you're only going to have to pay interest on the remaining balance, which is $100 in the event that you continue to make payments. In the other scenario, we're talking about deferred interest. So Retailers offer no interest. So it's going to be something like retailers offer no interest if paid in full in 12 months. The word you have to worry about is if. If you don't pay it off in 12 months, then the retailer or the credit card issuer, the creditor gets to charge you the interest that accrued during that period. So if you look over at the deferred interest portion, no interest if paid in full in 12 months, you buy a $400 TV. During the 12 months, you only pay $300. There's $100 left. The promotional rate during, there's no promotional rate during that 12-month period, it was 25%. So during that 12 months, the retailer would have gotten $65 in interest. The retailer now gets to add that $65 on top of the $100 that's owed. Now, in this scenario, there's only $400. So you can see even just borrowing $400 and having to pay $65, that's quite a chunk of change. So just imagine if it's $1,000 or $10,000, it adds up quickly. So when you're looking for promotional offers, be really careful with the zero interest first deferred interest. I see people fall into that trap and they're really surprised at the end when they have a really big hit in interest. I'm not going to go through calculating annual percentage rate, but it's here for you to look at later when it's on the website. You can come back and look at it. I would say the best thing is to Google APR calculator, and you can put in your own personal scenarios and you can see how much you are going to pay in interest based on the payments that you're making. So just so you have a visual, so the average right now, the average APR in the United States is 16%. And that's what the average consumer gets. So theoretically, you're thinking if you have a credit card that's less than 16% APR, you're in a really good place. I know some of my earlier credit cards that I got in college or in law school have, like a 20-25% APR. It's totally understandable. It's normal. So I would say don't feel bad at looking at this, but just take a look what APR means and what APR means applied to your situation. So here there's a $2,000 balance on a card, and in each scenario, you're making $100 payments. So if you have a 0% APR card and you borrow $2,000, if you pay $100 a month, you're going to have it paid off in 12 or in 20 months, and you're not going to pay any interest. In contrast, the average APR, if you make $100 payments on the $2,000 balance, it's going to take you 24 months to pay it off, and you're going to pay $315 in interest. In the last section, you can see a bad APR would be 25%, and still that same $2,000 balance, you're still making $100 monthly minimum payment, but it's going to take you 27 months to pay it off, and you're going to pay $614 in interest. So that's just a snapshot of how APR can really affect what you pay over time in interest if you're using it for that. The last portion that I want to cover on this, understanding a revolving consumer loan or consumer account, is the terms and conditions. So how do you figure out what's my APR? What's my APR for purchases? What's my APR for cash advances? This is all going to be contained in your terms and conditions. So these are the official documents and rules and guidelines to the agreement between the creditor and you as a cardholder. The Truth in Lending Act requires that credit card issuers disclose this information in a standardized way before you open the account. This is called the Schumer box. It's meant to be, even if you get a credit card offer, it's going to have a box, a grid line box, and it's going to be very clear on the different types of APRs that are charged, the different types of fees, and some other rules. So the terms and conditions page is usually divided into two parts. At the top, you're going to find the box, which contains all the rates and fees. And below that, you're going to see a dense collection of fine print that spells out the card's terms and conditions, such as payment allocation, rewards programs, and card benefits. Terms and conditions can change over the course of having the credit card. If you get terms and conditions and all of a sudden you went from a 12% APR to a 29% APR, you have the ability to opt out. The caveat with opting out is If you opt out, you're also saying that you no longer want to use this financial product. In order to close the account has to be paid in full. I've experienced, or we've helped a lot of individuals who said, well, I asked them to close the account and they didn't. They wouldn't close the account. So I kept getting charged interest and fees, but they still had a balance on it. So a requirement of closing out an account is having that account paid off. And I don't think it's going to be, I don't know if you'll have access to this, but I just really quickly wanted to. So the Schumer box, there's a link directed to it. And I just want to show you guys really quickly what this looks like. And this is from NerdWallet. It's the link, it has really good examples of terms and conditions of how to read your statements. But you can see this is kind of what I'm talking about when you're looking at this. So this particular box has the annual percentage rate for purchases, APR for transfers, APR for cash advances, penalty APRs, and kind of all the things that you need to, at a quick glance, see. This card has an annual fee, which means just have the card in your possession, you have to pay $59 a year. And it's got some transaction fees and some other items like that. So feel free to look at that when you're finished. And then the other thing that I really quickly forgot about that I want to touch on is for the penalty APR. So typically, there some penalty APRs kick in after 60 days. And what that means is if you fail to pay your account for 60 days, they can impose a higher APR. Other types of penalty APRs that I want you to be aware of, if you take out a card specifically for a 0% interest to make a large purchase, make sure that you're making the minimum monthly payments. Failure to make the minimum monthly payments on a 0% interest may kick in an APR penalty, meaning that your 0% interest is void and you don't get that. So you're expecting to not pay interest on this large purchase and all of a sudden you're paying 25% APR. So just be wary of those things and look around.
So I'm hoping that Jessica would be able to launch a poll right now, so we can get a little bit of a better sense of who's in the audience. I don't know, Jessica, are you able to do that or should I just
Sounds good.
power through? Okay, thank you. And Jessica, will you let me know when everyone's finished that?
Sounds good. We're about to slow down. People are rapid firing their answers in, which is great. Thank you,
Great.
everybody, for participating. And I'll share those results for that first question.
Thank you.
Would you like me to continue into the other polls or stop for a discussion on this?
No, just continue with the rest of the polls. We'll just get them all
Great.
out right now.
Okay, I'll launch that in a moment. And I'll launch the next one.
Great. We're trying to get a sense of who's attending here so we can try and tailor our presentations to the audience a little better for our next one. So I appreciate everyone filling this out for us.
And our last poll.
Okay, great. Great. Okay, thanks everyone. We really appreciate that. So now we've gotten to the point where you maybe have a few credit cards. You've got some balances that you can't keep up with. We're going to go through your options for getting on top of and getting out of debt. So the options available to you are going to depend on how much money you can put towards your credit cards each month, whether you can make all of your monthly payments and still have a little bit extra to throw at them, whether you can make some but not all of your monthly minimum payments, and whether you just can't afford any of your payments anymore. So I'm going to get into each of these different options in turn. Next slide, please. So no matter which of those three scenarios you find yourself in, there are two really important things that you're going to want to do no matter what. The first is just to create a simple budget with your income and your expenses, see where you could maybe cut some expenses and throw some more money towards your credit cards every month. And then you're also going to want to make a debt spreadsheet, gather up your most recent credit card statements, and then list out the balances, the monthly minimum payments, and the APR. You want to understand your big picture financial situation, and then you can use the debt spreadsheet to track and update your credit cards as you work on paying down your debt. The other thing that you're always going to want to do is just call your creditors directly. Longtime customers, especially ones with a history of paying on time, can sometimes work out lower interest rates or better deals. And a lot of creditors will also offer some sort of payment plan, usually to distressed customers. So for those, you often already need to be in default on your account to qualify for them. So if you can meet all of your monthly minimums and you have a little extra and you're just trying to get your debt paid down, you can lower your debt by just prioritizing one card at a time. You can pick one of two options. You can choose the card that has the lowest monthly minimum. This one you'll be able to pay off the fastest, so you'll have one less account to worry about. Or you can pick the card that has the highest interest rate, and that'll save you from paying more interest in the long run. Regardless of which one you pick, just target it with throwing as much money as you can spare each month until that card is paid off, and then move on to another card to target and keep throwing the same amount of money every month towards all those minimums. Okay, next. So if you're having trouble keeping up with your monthly minimum payments, you can do something that's called debt consolidation. The basic idea is to try and get a lower APR on some or all of your credit card debt, so you can pay lower monthly minimums and you can pay less in interest overall. So one way to do this is a balance transfer. You'd just be moving credit card debt onto a new credit card that you open up that has a lower interest rate than the existing one you're paying. And Erica was talking about introductory rates, introductory APRs. A lot of times you'll get offers for 0% APR for the first 18 months. This gives you a little bit of time to work on, getting your balance down without accumulating more interest. So you're not shoveling in a snowstorm anymore. But you do need sort of a better credit score in order to take advantage of those. And another option is to do a personal loan and just use that to pay off your credit cards and then just focus on the one loan with a lower interest rate. Lots of banks will also offer specific debt consolidation loans, and those usually have much lower interest rates than what you're paying on your credit card. But again, for both of these options, the better your credit score, the better deal you're going to get for consolidating your debt. You'll get lower interest rates, and you'll get more access to credit. So for example, a new card that has a 0% APR introductory rate will give you a $7,000 credit limit instead of a $3,000 credit limit if you have a better score, so you can transfer more of your debt over to that lower APR card. Okay, next slide. Another option is credit counseling. It's a service that's offered by nonprofits. You can take advantage of it regardless of your credit score. They act as a financial advisor for you and give you advice and resources on managing your debt. And they'll often offer an introductory session completely for free. They also a lot of times have debt management programs, or will put you in a debt management plan. You'll pay them a fixed monthly payment, and then your credit counselor is going to try and get lower interest rates on your credit cards. Again, you don't need a high credit score to do this. And the nice thing about it is that you have a very clear, yes, thank you for pointing that about the balance transfer fee. Yeah, I forgot to mention that. Okay, next slide. So just in general, financial services for consumers who are in distress with credit card debt, they are rife with companies looking to scam people and take advantage of people. It's very important that you do your due diligence on any company that you're thinking about working with. With credit counselors, there's American Consumer Credit Counseling is a large national reputable credit counselor. You also want to look for places that are nonprofits that are accredited by the National Foundation for Credit Counseling or Financial Counseling Association of America. And you also want to make sure that your credit counselor is upfront with you about the fees and the costs of all the services that they're going to be providing for you. Next slide. So debt settlement companies or debt relief companies are very attractive options to consumers, and they're something that we've seen a lot of clients in distress turn to. They're almost never a good option for people. I'll explain why in more detail. And even though we say that they're almost never good for people, I do want to kind of go through the mechanics of how they work, because they can be very attractive, and you or people you work with might find themselves being seduced by one of these companies. The general way that it works is you stop paying your credit cards each month and instead pay a fixed monthly fee to one of these companies. They're going to then wait for your monthly fee to accumulate into a bigger lump sum. And they'll use that to negotiate settlements with your creditors. Then the fee that you pay them is a percentage of the original balance of your debt, not the settled amount, the original amount. Next slide. So this would be a pretty typical account with a debt settlement company, someone who has 4 different credit cards, a total of $21,000 in debt. So they'll start by making say a $300 a month payment to the company. That's pretty typical. And it'll start getting deposited into their settlement trust account. Next slide. Then after, say, 5 months, you've got $1,500 in your account, and the company is going to negotiate a settlement with, say, Discover Card. They worked out a $5,000 settlement on an $8,000 balance. So then they're going to start making monthly settlement payments to Discover, say $150 a month, to start hitting up to that $5,000 settlement. And then once they've made that settlement for you, they can start taking out their fee of $25,000 or 25% of the original balance. So their total fee for settling this one debt is going to be $2,000. And then they're also going to be charging you various monthly maintenance fees, things like $10 a month to maintain your settlement trust account, $10 a month, or $10 to cut a settlement payment check to Discover, things like that can add up pretty quickly. Next slide. So after a few years with one of these companies, where are you going to be? This is a pretty typical example. They've settled 3 out of 4 of your accounts for maybe about 50% of the original debt. It's pretty good. But you still have a $4,000 debt with JP Morgan Chase. They've refused to engage in any settlement negotiations with this company. And in the meantime, they've decided to sue you for non-payment. So you had an original debt load of $21,000. It's now down to $14,000, 10 of it settled, 4 of it still existing. And then you've also paid 25% to this company, so $4,250 plus all these additional maintenance fees. So you're barely saving any money if you are. And in the meantime, you've stopped paying your credit cards, so they've all gone delinquent. Your credit score has taken a hit, and now you're being sued by JP Morgan, and the debt settlement company is very likely not going to hook you up with a lawyer. They're not going to assist you with the court case at all. Next slide. So some of these companies are legitimate and do comply with the law, but there are a lot of scams out there as well. So you should be very wary of any company that asks you to pay them fees up front. Legally, they can't charge you any fees until they've made at least one settlement of your debts. Any company that's pressuring you to enroll quickly, take advantage of this deal, sign up in the next 24 hours, or any company that's going to make guarantees about how much they can settle your debt for, how much they can save you. But like I said, even legitimate companies are probably not a good deal for you. sort of a stress relief to have your debt management outsourced to a company and having them handle all the settlements. But again, it's very likely that you're not going to save any money and you might be financially worse off when you finish with them. Next slide. So for the final situation where you're not able to make any of your monthly minimum payments, you basically have two options. The first is just to wait to be sued. We're going to talk a lot more in detail about the process of going through a lawsuit in a little bit, but I'll just say briefly that creditors have 6 years to sue you. So it's not necessarily a guarantee that they will. So you can just try and wait it out and see what they do. Next slide. The final option is basically the nuclear option, filing for bankruptcy. It gives you a fresh start. It discharges most of your debts and definitely your credit card debts. But on the flip side, not all debts can be discharged. Federal student loans are really difficult to discharge. Criminal fines and fees, child support debt can't be discharged. It can be a really emotionally tough process to go through. You have to, go through an exhaustive list of all of your financial assets. And it's also on your credit report for 10 years. So creditors will see that when you're looking for credit, and it could be difficult to get loans in the future. Next slide. Oh, Erica, you're muted.
My bad, thanks. So just as we move on, I do want to touch on a couple of things that Lauren spoke about. And I understand that debt settlement companies are really attractive. And I've dealt extensively with debt settlement companies at my previous job. It's pretty much a majority of the entities that we're settling or settling with on accounts that I was trying to collect on through lawsuits. So the one thing I want to say is that I think it's attractive because you're getting the debt consolidation company is saying, give us one payment and we're going to disperse those payments for you. The one thing I want to say is debt settlement companies are not by rule getting a better settlement or working out a better payment plan than you can. Now, if the debt settlement company does that, it may be because there is an experienced negotiator or maybe because they're aggressive, but whatever deal the debt settlement company is getting on your behalf, you can get that same deal. The key is communicating and being honest with the entity that you're communicating to about your finances. But whatever the debt settlement company, if they can get you a 50%, 50 cents on the dollar settlement, you can also get 50 cents on the dollar. If they're getting you 30 cents, you also have the ability to do that. It may require some research. There's tons of resources out there on how to advocate for yourself and how to get yourself a good deal. But don't think that they can get you some deal that you can't get yourself. It's just something that I really quickly wanted to touch on because that was a common misconception previously when dealing with debt consolidation companies and their clients who were defendants on the other side. All right, so we are moving on. Sorry, so debt collection, know your rights. All right, so I'm going to move on really quickly. All right, so let me go to this slide and then I'll move back. So let me just give you a brief timeline of kind of how it works out and what's going on with the process. So the way that it works is we're just hypothetically going to talk about one account. So credit card goes into default. So that means you stop paying on your credit card. Either you can't make the monthly minimum payments or you've just decided it's better to just let this go for whatever reason. After the account goes into default, after you stop paying on the account, it varies, but the account it's going to be charged off, which means that the company has deemed that you are not going to pay it back and they're going to close it and look for their other options. Now, typically this happens after about 3 to 4 months of non-payment. During COVID, I was still at my last job. During COVID, we saw credit card companies waiting over a year before they charged off credit cards. So it varies. It should be in your terms and conditions, but COVID was a weird time and there was tons of rules and legislation enacted because people were having a difficult time paying their debts. So eventually, after you stop paying your card, it will be charged off. It's kind of the gist of it. How long depends. And then a couple of things happen. So either the financial institution that made you, that lent you the money and you got your creditor, either they're going to keep the account and they're going to internally try to collect on it. And that may happen one of two ways. Either they're going to place it internally in their own collection department, or they might farm it out to another collection agency. Alternatively, they may farm it out to a collection law firm. So those are three, really two different ways, either just via collection agencies or via a lawsuit, and your original creditor will still own the debt. The other approach that creditors take in order to, I don't know what the reason is that they do this, but a lot of creditors, once they think that they're not going to be successful in recovering money from sets of accounts, they take those accounts, they bundle them into these huge portfolios, and they sell them to third-party debt buyers. And those third-party debt buyers also take the same approach. Those third-party debt buyers either farm it out to a collection agency, it tries to collect on it on its own, or it also places accounts with attorneys for collection. So the one thing I just want to touch upon, which was a big thing. It is a big thing generally, and you see it a lot, or we see it a lot when we go to court. Is I just want to make you aware. So there's a really important legal distinction, and when you go to court, or if you're being sued, or just even being collected on, whether you owe the money, whether you're liable for it, whether you made those purchases, whether you owe the debt, is a totally separate issue than whether you have the ability to pay on that debt. So if you're being sued by your creditor, the lawsuit is about whether you owe the money. A lot of people come into court and say, yeah, I owe the money, but I can't pay it. I just want to make sure that you're really aware of that, because the liability portion is really important and separate. Whether you can pay the debt, that issue is raised later in the litigation process. So when you're being sued, it's really, are you responsible? Do you owe this money? And we're going to talk about some of the defenses that you have to argue whether, if you don't believe that you are liable for the money. The other thing is statute of limitations in Massachusetts is 6 years. That means that if the debt is older than 6 years old, you have a legal defense to a lawsuit being filed against you. Now, in Massachusetts, it's either from the last date of payment. So let's say, for example, the last time you paid on a credit card is December 31st, 2022. And actually, let's do, so January 1st, 2023 is the last time you paid on a credit card. And by April 1st, it's charged off, which means that it's closed. The credit card company or the creditor or whoever owns that debt has 6 years from the latter of those two dates to sue. So if all of a sudden you get a lawsuit in 2030 for a debt, well, it's been 6 years since the last payment or since it's been charged off, or I guess 2031, sorry. 2031, you have a defense. If you're sued, you can say that debt's older than 6 years old, and that's a defense that comes up. But just be aware, and if you move to other states, so if you move from Massachusetts to New Hampshire, and it's been 4 years, and all of a sudden you're getting hit with a lawsuit, well, the statute of limitations in New Hampshire is 3 years. So you've beaten the clock. So those are just things to just be aware of to start with, and just like as a bigger picture.
So once you're in collections, it's important to know who is the entity that's attempting to collect from you. It might be a collections agency, but they have no legal recourse. They're not going to be able to sue you. They're just trying to get their money out of you and make a profit off of the debt that they bought from your original creditor. And then there's also collections law firms, and they do have the ability to sue you. But regardless of who is attempting to collect from you, all debt collectors have to follow the Fair Debt Collection Practices Act, the FDCPA. Massachusetts has even stronger protections in its own debt collection regulations. Debt collectors have to identify themselves. They have to be licensed. They have to tell you the debt that they're calling about. They might need to confirm some identifying information from you, like the last 4 of your social, but be wary of any debt collector that's attempting to get more personal information from you, like your mother's middle name, your full social security number, bank account information. That's not information that they need. And we're just going to skip that last part. Erica, you want to go to the next one?
Yeah.
They also, there's lots of regulations guiding how they have to communicate with you. They can't call you during normal waking hours unless they know that you work the night shift. They can't call you at home more than twice in 7 days. Can't call you at work if you ask them not to. That lasts for 10 days if you make that request verbally, indefinitely if you make it in writing. They also can't call you more than twice every 30 days at work. They can't threaten or harass you, can't use foul language, can't make repeated calls over and over just to annoy you. And they also can't lie or deceive you. They can't misrepresent anything about the amount of debt that you owe them, about legal actions they can take. For example, if your debt is beyond the statute of limitations, they can't threaten to sue you, and they can't threaten to have you arrested.
All right, so legal process. All right, so so everything's going to start out, and we're going to. Sorry, these the windows are a little distracting for me. Okay, so 30-day demand letter. So the typical way that it works is a collection law firm is going to get a series of accounts, and they're going to have to verify the information on the account to make sure that they have all the proper documentation in order to file a lawsuit. And once the collection law firm has determined that it in fact has everything that it needs from its client, it's going to send you a 30-day demand letter. And the 30-day demand letter is essentially just a letter letting you know, hi, we are such and such entity. We have the target card. We have your target card account in our office. Our clients told us that you are unwilling to or unable to make payments. If you don't dispute or if you don't dispute this debt, or if you don't answer us within 30 days, and if there's no communication, we will potentially seek legal recourse. And there are important parts of that letter that are required. We don't have a sample letter. It's two in the nuance. We perhaps will do something so that you can really look, but it's got to have some basic information. And it's got to be addressed, you know, make sure that your name's on it. It's your address. It's your card. If you don't recognize it, or even if you do, then just you have the ability to ask them for a validation of your debt. And in reality, it's in your best interest to just go ahead and reach out. I know that it's difficult sometimes to have these kinds of conversations, but you have the ability, you have the best ability to negotiate on your behalf. Or even if you don't have the ability to negotiate, that's kind of your window to talk to whoever. And let's say, for example, we're going to cover this a little bit later, but let's say that you are retired, you're in your 80s, your only income Social Security, you don't own a house, you don't own a car. There's basically no way, unless you win the lottery, that this creditor is going to be able to get any money from you. Communicating that to your creditor is good right off the bat. Or I would say, for example, if somebody called me in my previous role and those were the circumstances, I would send that account back. I would send it back to my client and say, there's no way we're ever going to get any money out of this. We're not going to proceed through the legal process. I'm not saying that's going to happen all the time, but there is the ability to at least relay what your circumstances are. So in the event that you send the law firm sends you a 30-day demand and you're not able to negotiate some sort of payment agreement during that time, the next process is sometime after the 30 days, a lawsuit's going to be filed against you. During the lawsuit, that's going to be litigated. And the way that happens is if you're sued in small claims, which is under the balance is under $7,000. There's just one small informal hearing. It's called a magistrate hearing. It's essentially a small trial. And there's going to be a determination on that day. For district court, you're going to be served with, in both instances, you're going to be served with notice of the lawsuit. In district court, it's actually going to be litigated. So you're going to file an answer. You must file an answer for it to continue. And failure to appear at any of these hearings or failure to respond in any way is going to mean that the court can automatically enter liability against you, which means that a judgment can enter against you. And what that means is that the court has found that you are legally liable for the debt. Now, whether you have the ability to pay that debt or not is a separate issue, as I said. But the legal process is figuring out if you are liable for the debt. And I'm sorry, this window is, there we go. Okay, so in terms of defending the lawsuit, so you have a better chance of defending the lawsuit if it's a third-party debt buyer. And the reason that is because when the original creditor sells the debt off, typically it costs the debt purchaser, the debt buyer, costs them money to get all the documents associated with the debt. And in the state of Massachusetts, requires a lot more documentation from debt buyers in order to prove that the debt purchaser has the legal right to collect on that debt and that they owe the debt. So if the debt purchaser doesn't have proof of ownership or proper assignment, you do have a defense there. For original creditors, it's a little bit harder to dispute, but there would be good documentation if you are able to dispute. So typically identity theft or fraud are really the only ones that are going to overcome an original creditor claim. And that is, quite literally, you left your wallet on the train and somebody took the credit card and they made a bunch of charges. Now, in the event, you're going to have to look at your terms and conditions. Even if this happens to you, there's things that the creditor is going to ask for. Well, did you file a police report? Did you let us know about it when it happened? And if you have those items and you went through the proper steps to dispute those charges at the time that it happened, you have a greater ability to prevail on your claims of identity theft or fraud, which would, ultimately possibly not find you liable for the outstanding debt. And then procedural defenses, it's outside of the statute of limitations, or Massachusetts has these specific rules called 8.1, and it requires entities suing you on specifically revolving credit. So that means credit cards. It has all of these requirements to provide paperwork. If you're able to look through the 8.1 affidavits and requirements and find a snag in there, and it might be something as simple as the firm is supposed to send you a 30-day demand. In the lawsuit, the plaintiff is required to show you proof that you received or that it sent out a 30-day demand letter within the previous 3 months. So if you look through your 8.1 affidavit and they sent you a letter 6 months ago, it's something that you can bring up because the rules say that the letter must have been sent within the last 3 months and there wasn't a letter sent. So those are just some examples of some of the stuff for defending a lawsuit.
So once the liability determination has been made, and the court will, if the court finds you responsible for the debt, they're going to enter what's called a judgment. It's just a court decision to that effect. And the judgment is then what the creditor uses to actually collect money from you. They'll have 20 years to collect on that judgment. And during that time, the judgment will grow at 12% interest.
And at this point, I just want to quickly say, so a recent trend, I don't know how recent, so in the last 10 years, large national banks have been waiving interest. So if you are sued by JP Morgan and it secures a judgment against you for $10,000, in 10 years, that judgment's going to be $10,000, most likely. And this is, like I said, this is the last 10 years or so. It is, I don't know about small institutions such as local credit unions or some smaller creditors, but the large national banks, I just want to put that out there in the event that you now have a judgment entered against you and you're responsible for paying an original creditor, so the person who lent you money, JP Chase, and there's a separate judgment from a debt buyer. In the event that you are looking to pay those off, I would say probably tackle the judgment that has interest occurring on it. And that's going to be on the actual judgment that you receive from the court. It'll let you know whether interest is accruing or not. So just take a look at that and be aware of that, because 12% interest is astronomical, and it really adds up fairly quickly. Okay, so what happens after a judgment's entered? So in small claims, like I said, that's going to be anything under $7,000. In small claims, it automatically schedules, the court will automatically schedule a payment review. And I just want to take this time to note, so payment review under small claims, and under district court, the third prong is supplementary process. Both of these things are just ability to pay hearings. So you're going to show up. There is an official form, and it asks you about your income, what your source of income is, what your assets are. And essentially, the court makes a determination on whether you have the ability to pay. And if the court determines that you do have an ability to pay, and if, you know, there's a lot of things that you can do in order to disagree with the court order, but, you know, the clerk may enter a $25 a month payment order, which would mean that you are responsible for paying $25 a month. In the event that you don't, you know, pay on the payment order, again, the creditor is going to have to take you back to court. They're not going to, you know, they can't arrest you and put you in jail for failing to pay the order, but it does have there are legal consequences, or, you know, the legal portion of it continues as they're just going to keep dragging you back to court. So for small claims, it's called a payment review hearing. In district court, it's called a supplementary process. Now, that's a separate action that has to be filed. And again, if you communicate with your creditors and right off the bat, let them know, in the event that you are on Social Security and you are 80 years old, you know, letting the creditors know that will reduce the chance that they're going to take you to court when they know that you don't have the ability to pay. Other things that happen in district court, other remedies, or just even in court, is they can attach your wages. So the creditor can move to attach your wages. Of course, this is a separate action. You have to get notice. And the other thing that can happen is if you have assets, those assets are at risk for having a lien placed against them. So if you have, if you own a house, and so let's say you own a house and Citibank gets a $5,000 judgment against you, what it can do is it can go down to the registry of deeds and can take the execution and it can record it against your property, meaning that it has a $5,000 lien on it and it's a cloud to your title. So in order for you to sell that house, you're going to have to pay off the judgment and then the execution will be removed. The creditor also has the ability to seize property, but you have to have substantial Lauren, what's the word that I'm looking for?
I don't know.
Equity, sorry. You have to have substantial equity in it. So the most common one is, so the example would be, I'll give you two scenarios. So Citibank has a $5,000 judgment against you and you own a Ferrari worth $100,000 and you don't have a loan on it, you own it outright. Because you have so much equity, because you have $100,000 in equity, you can place a lien on your vehicle. And there's a process with the sale. But if you own a car that's worth $5,000 and you have a $5,000 car note in it, you don't have any equity. So it's not at risk. And that's a whole separate, I'm getting a little bit too into it, but there are abilities, but you have to have serious equity in property for any of these things to be at risk.
Okay, we are almost out of time, but this is unfortunately probably the most important part of our presentation, but I'll go through it quickly. We have really strong protections in Massachusetts and federally to make sure that people aren't left destitute by creditors collecting on judgments, and you can protect certain sources of income. All income that comes from public assistance, Social Security, retirement, disability, unemployment benefits, workers' comp, all of that cannot be touched by your creditors. And then for wages, if you're working, you can protect either $750 a week, that's $15 an hour minimum wage, working 50 hours a week. Or if you make more than that, 85% of your taxes or of your wages pre-tax. And you can also protect income that's used for certain necessary things like housing and groceries. Next slide. And then assets are also protected. Your house, that has to be a residential home that you live in. You can file what's called a homestead exemption with the Registry of Deeds and protect the value of your house up to $500,000. You can protect up to $1 million under a homestead exemption if there are more than one homeowners who are over 62 or disabled. And then without the exemption, it's $125,000. And you can protect your car for up to $7,500 in value and twice as much if you're disabled or an elderly debtor. There's also some other personal property that's protected. Most of it's probably not relevant, like livestock, which shows what an old state Massachusetts is. But you can note that you can protect cash up to $2,500. And then there's also a miscellaneous category where you can protect up to $6,000 of other personal property, including cash. Next slide. I think this is our last one. Final note on collection proof, there's a category of sort of extra collection proof people who are either 60 and older or permanently disabled. If you're not in this category, the creditor with a judgment against you, like Erica said, can keep taking you back to court to assess your ability to pay. Maybe you got a raise, maybe you're making more money now, maybe you won the lottery. But if you're in this extra collection proof category, the court has to dismiss the first payment review proceeding and you're not going to have to go back to court. I think that's all we have. 2 minutes over.
Thank you so much. Don't worry. I know we have a lot of questions in the Q&A and in the chat, but I'll make sure that we get those to you in our follow-up email, which will also have the link to this recording. Thank you so much, Lauren and Erica, for being here and for taking the time to talk about this super important topic. And we'll make sure that when the follow-up email goes out, we'll have a little bit of an overview as well.